to present this lecture about the final trials of the Iraqi High Tribunal. Let me tell you a little bit about Mike Newton. I met him years ago when he was the deputy to the ambassador at large for war crimes issues at the State Department. Before that, he was a colonel in the Army JAG Corps, and he was stationed in all sorts of interesting places and had a very distinguished career. He then became a professor at West Point, and then later, and currently, he's a professor at Vanderbult Law School. We served together in the preparation of the trial of Saddam Hussein and met with the judges and the prosecutors in various locations around the world and helped to train them for what became one of history's most interesting, to say the least, trials. And after it was over, the two of us co-wrote this book, Enemy of the State, which came out in St. Martin's Press. It was a mini bestseller. It won a National Book of the Year award. And if you are interested in getting these books or seeing the Q&A and some of the video and other presentations we've done, we have a book website. And up here are little cards you can pick up after this is over. Now, Michael has just returned from Iraq, and he's been doing exciting work there again. He spent a lot of time in Iraq during the trial, and he's one of the few people that are not risk adverse, and he's a lawyer who doesn't mind going in where the danger is to make a difference. And so you are going to have, I'm sure, a very exciting presentation today. He'll speak for a while and then open it up to your question and answer. And let's please join me in welcoming Professor Michael Newton.
Well, thank you for the graciousness, and thank you for coming on a Friday in a beautiful, beautiful Cleveland day. I know this is typical Cleveland weather. So you have a typical law school lunch, and so life is good, as they say in Alabama. La dolce vita. It's all good. This, by the way, is, I would unbiasedly tell you, a very good read and makes a great Valentine's Day present. Don't forget. So what I want to do is to give you a bit of the history, but it's important to understand the context, as the history then feeds two of, and I think it's fair to say, two of the most important, most visible landmark genocide cases in world history. So we always think about the Rwanda genocide and lots of case law from that. We think about the Balkans, we think about Srebrenica and lots of genocide jurisprudence from that on all these substantive legal issues. And unless you take that third step then and say, well, the Iraqi genocide cases rank right up with those cases in terms of merit, in terms of the legal issues raised as comparable case studies, you're missing a bet. There's a huge amount of really important law here, and that's all I want to do in about the next 15 or 20 minutes, is give you a sense of that law and the comparable issues so that we can then have some good discussions. Sort of the teaser, and then you can go to sleep or go get more pizza and zone out with your post-lunch buzz. The two major genocide cases in the Iraqi tribunal, of course, the Anfal case, which everybody in the world has heard of who works in this field, significant case, the second case, where Saddam Hussein was charged subsequent to the case that we wrote about in our book. And the thumbnail Reader's Digest version is a substantiated case of genocide. So it's a hugely important 900, almost 1,000-page opinion documenting the genocidal issues and the genocide context, and I'll talk about that. But the companion case, the Halabja case, how many folks have heard of Halabja? You know, see, I made this mistake the other day. I said, well, everybody's heard of Halabja, and I had a group of students who looked at me and said, Professor Newton, one of them started, Professor Newton, we weren't born yet. I'm like, oh, right, okay, let's back up. These were undergrads. Halabja was an instance in March, and this is important because we're quickly approaching the 24th anniversary. March the 16th to the 19th, for a period of 3 days, Iraqi forces used chemical weapons against this particular village. And by the way, just as sort of a helpful life hint to you, I have we talk about Holocaust survivors. I have a Halabja survivor who's a very dear friend. He happened to be an undergraduate student at Baghdad University who was home on spring break in Halabja. when they began to, so he was young, obviously, he was a college student, they began to launch these chemical weapons strikes, and over the next 3 days, he, like everybody else in Halabja, hid in their basements. So my life tip to you is if that ever happens to you, don't hide in your basement. Because what happens is it turns into its own little self-contained gas chamber. And that's what happened. Most people died in their basements because of this concentration of chemical weapons. And of course they tried to use rags and things, but it didn't work. So your best bet is run outside, run far away, find a low-lying ditch, and lay there until the stuff clears. So I want to take about the next 15 minutes and try to demystify some of these issues for you. This is all, I would say, complicated by the political dynamic and by the circumstance from the West, given that we don't really understand these trials. We don't study them in law school typically. That's why you need to read this book. But more importantly, most of the opinions aren't available in English, or if they are available, they're fragmented, there's bad translations. Unless you speak Arabic, you can go back and watch the DVDs. The thoughtful, analytical, legal commentary in these cases has been sorely lacking. So that's why I want to spend a chunk of time today sort of answering your questions, a little bit of a compare and contrast, so that you understand the relevance. And I really mean this. If you're going to write in this field, there's the Rwanda cases and the line of cases, there are the Balkans line of cases, and the Iraqi line of cases on the genocidal issues stand right there with them in terms of the legal issues raised. There's no question about that. So I just want you to understand that, and then understand some of the legal issues associated with that. All of which, of course, goes back to Nuremberg. And Nuremberg, in a sense, the core legal issues predate Nuremberg. Much of that is true. But Nuremberg is the most visible landmark, the International Military Tribunal, that we focus on in terms of bringing these issues to the fore, both of international politics, but also of international law. So in Nuremberg, for example, we validate the doctrine that defense of superiority is not a valid defense. Okay? You see that issue raised in the Iraqi genocide cases. When they say, hey, it's not me, I'm the ultimate political legal authority, but it's really central Baghdad, or it's really, there's a finger shifting. And it goes straight back to Nuremberg. And we'll talk about how that played out in the context of the trials. The concept of crimes against humanity. How many folks are in your basic international criminal law course already? Good. So if I say the Martins Clause, how many folks know what I'm talking about? The basic Martins Clause language that comes from the Brussels Declaration and then shows up in the preamble to the 1907 Hague Regulations. And this is law of war. Okay? It says until there's a more complete code of law, the basic principles of humanity will fill the gaps, the interstices of the law, if you will. At Nuremberg, the International Military Tribunal, we then create this composite category. We call it crimes against humanity. And here it is, for the first time in international law, as a positive body of law, technically, theoretically, no question, that goes back to the Martins Clause language. Why do you care? In the Iraqi context? Fundamental question. Given this now very well-developed body of law called crimes against humanity that goes back to the international military tribunals and is reflected in every existing statute and every set of jurisprudence, which body of law has precedence? And this is a big debate. Does genocide law automatically have predominance? Because after all, it's the G word, right? This is the crime of crimes, says Ben Ferencz and a lot of people. Or do we take a much more technical approach as technicians and as craftsmen and do a very technical, analytical approach and say, well, it really doesn't matter on the merits, right, between a conviction of genocide or crimes against humanity. What counts is that we have fidelity to the technical elements of the crimes, to the technical, lawyerly craft of matching the available evidence against these available crimes. In the Iraqi genocide cases, you reach, on that issue, conflicting results. In the Anfal genocide case, no question genocide is proven, no question there's a whole range of genocide convictions that flow from that. In the Halabja case, very similar facts, which I'll give you in a minute, different result. They reject genocide convictions and convict on the basis of crimes against humanity. Except for the dissenters, and this is sort of novel in Iraqi practice, you get dissenting opinions. It's kind of cool. These Iraqis writing vigorous dissenting opinions saying, we think genocide was proven. So this debate is very clearly keyed up in the context of this jurisprudence. And then the last big issue is something that I know you're all familiar with, and it goes beyond just the narrow technical issue of defense of superior orders. It goes to the broader field of what we would call in the business the grounds of individual responsibility. How much of a linkage do I need to show to convict you for an activity in a place that you've never visited, that I can't show a direct line of orders that you didn't specifically authorize? How do I take your appropriate role in the bureaucracy and then track it out to a particular place at a particular crime carried out by, in many cases, people you've never even met? So there's this wonderful moment in the Halabja case where Ali Hassan Al-Majid says, I've never been to Halabja, right? I don't want to go to Halabja. He says, it's a pox, right? The place stinks. He said, I think it should be blown up and shipped into the sea. I don't want to go there. I've never been there. I don't know anybody there. You can't hold me accountable for activities in a place that I've never been, that I wouldn't want to go. And so there's this very rich, extended analysis of what in business we would say the grounds of individual responsibility. And I can answer lots of questions about how this plays out in the jurisprudence. The thing you need to know is that what the Iraqis did was, in some ways, a reapplication of the basic law in a very different context, but in some ways also quite original. And it's original for a very interesting reason. How many folks are watching Libya right now? Thinking, gee, how's Libya going to resolve itself? How's Syria going to resolve itself? We've had experience on the ground in Uganda. And what you're talking about is this process of taking an individual piece of international law, in this case the grounds of individual responsibility, and transposing it into a domestic context, where you're operating against the backdrop of domestic rules of procedure and domestic rules of evidence. And what the Iraqis did in these two cases, as I said, is in a sense unremarkable, because they take this international law and they domesticate it, but then it's got this distinct flavor and distinct language drawn from domestic law. Okay? And that's what makes it interesting to study. But again, on these issues, in the Halabja and the Anfal case, you see a sharp distinction in the approach and the technical lawyerly approach. And I'll talk about that in Q's and A's. All right, so this is actually the slide of the day, the press conference, where the Iraqis announced the development, the formation of the Iraqi High Tribunal. And you can see, I mean, you really don't need to know the names. I can tell you the names and the stories behind all this. The key thing, though, is how many Westerners are in that picture? Nada. See, that's the point. It's a ground-up, it's an Iraqi-led process, similar to what the Libyans need to be doing right now today, similar to what the Egyptians have done in some ways, which is to take international expertise, international advice, but build a system from the ground up. That's exactly what they did. And therefore, they created a composite legal structure where they take crimes drawn from international law, the typical crimes that you study, that we practice in, genocide, crimes against humanity, and all the range of war crimes. Very straightforward application, domestication, if you will. Right? In that sense, pretty uncontroversial, except that revolutionary. Because remember, what you're doing is you're taking this body of international law and you're implementing it in the fabric of your domestic criminal procedure code and your domestic substantive code. And in that way, revolutionary. Arguably, let's just say this, arguably ahead of many, many, many much more developed Western states, to include the United States, which has no statutory basis for prosecuting crimes against humanity as such. You see? And in fact, even on the war crimes count, the United States and other Western countries has war crimes built into their domestic fabric, but not to the same extent that the Iraqis did. The Iraqis took the whole range of crimes from the Rome Statute and built them into their domestic code. But importantly, they also built in a core set of domestic crimes. From their perspective, they said this set of domestic crimes in Article 15 is just as important to us as crimes against humanity. And it's, who's to say they're wrong? From their perspective, to build a long-standing, successful, sustainable peace, you had to deal with things like the destruction of the southern marshes, right? You had to deal with things like the burning of the oil fields. You had to deal with these very core things that were very important to the national consciousness. And why do you care? Well, you should care because you're lawyers. But apart from that, other countries around the world are going through exactly the same thing now, and I will tell you that it's those crimes, it's this body of law that leaves the lasting societal, cultural scars in a place. You want to bring long-term sustainable peace to Libya, or Tunisia, or Tripoli, or Kosovo, or any of these other settings. Certainly we've seen it in the Balkans. This is the core body of crimes that you have to address. Because if you don't, you've left this festering societal, cultural wound that creates instability long term. And so that's what they're trying to do. Cast of personalities here. You've heard of Ali Hassan Al-Majid. Here's his picture. What you really need to know about Ali Hassan in the context of these cases is that in 1987, Saddam made him commander of the Northern Bureau, meaning you have all plenary authority. I devolve to you, my cousin, all plenary authority over the Northern Bureau, which is the Kurdistan region, the Kurdish northern area of Iraq. As the commander of the Northern Bureau, what's interesting about this is similar to what the Germans did. There is political authority and political power and military authority, military power, consolidated in that position. Okay? So, for example, is anybody writing on the General Kersted's case in Srebrenica? You know, there's an interesting comparison in that case, in that line of cases, between the military officials and the civilian political officials. And it creates evidentiary problems, it creates proof problems, it creates this problem when military forces are acting, no question they're under the line of military authority, but when the policy has been crafted by political officials, what's the connection there? You see? In this line of cases, those issues are much simplified because, by virtue of Revolutionary Order 160, those powers are consolidated in the single person of Ali Hassan Al-Majid. You see? It doesn't stop him at trial, of course. He says at trial, hey, I had nothing to do with this. This was all the central government from Baghdad. These were all direct orders of Saddam Hussein. And in fact, one of his pieces of evidence for that, who wants to play judge? Who wants to be a judge? Judge. What's your name?
Haley.
Haley. All right, Judge Haley. Ali Hassan Al-Majid says, yes, I have this plenary, consolidated medical and political power. But it's really not me, because yes, there was bombings and gassings, but the planes took off from areas outside my scope of control. The actual bases for those planes are in areas outside the Northern Bureau. Are you persuaded by that?
No.
Good, because the Iraqis weren't either. The Iraqis said, no, we have your fingerprints on all these other ways. That's not a dispositive element to disprove your individual responsibility. Okay? So Ali Hassan backs up, of course, and takes the tried and true Nuremberg approach. And well, that's just superior orders. Right? It's just I'm just the messenger. I'm just the implementer of somebody else's orders. Can't hold me responsible. Judge Haley? No. Well settled law there. No. Okay. Let me stop for a second. I'm about to give you a history lesson, a quick history lesson. But let me stop for a question and see if there's a burning question or a burning concern that's popped up in your fertile law school brains that you want to deal with before I move to some history. Anybody have any sort of burning, overarching, legal, technical, substantive question? Anybody? Going once, going twice? Yes, ma'am.
In terms of the law, to what extent was it purely domesticated, and when they domesticated it, did they take into consideration, like, did they allow for interpretation of international law to mesh into their decisions?
I think what they did was actually reflective of the very best practice, and I say this intentionally. They took the substantive components of the law, so genocide, war crimes, and the whole range of crimes against humanity, the whole range from the Rome Statute. So the substance of the law is precise. And then they did two very important things that I think reflect the best practices. Number one, they said, in applying, well, and then the backdrop to the substantive law is the procedural law, which is domestic law. So domestic processes, domestic procedures, pre-existing, except insofar as they are modified by this new statutory structure. So domestic procedure tweaked with international substance, but now you know, if you want to think of it, it's transposed. Now it's not really international substance anymore. It's domestic substance because it's been domesticated. Here are the two best practices, though, and the statute says this. Number one, the judges may make reference to the international jurisprudence. Doesn't that make sense? Right? And then number two, Iraqi domestic procedural law, insofar as it clashes with the best practices developed in applying on the international level these substantive crimes, can be modified by the judges. So you see what's going on? It's a merger. It's a melding of the two systems to get it right. And I think that's important to remember. I also think it's important, as the Iraqis attempted to do in these cases, when you've done that, you must document it. You must write about it. Here is how we are taking these principles, and in great detail. That's why the Anfal case is almost 1,000 pages long, because it's an extensive explanation of procedural and substantive rules, and they try to lay it out in a way that people can understand. Does that make sense?
Yep.
All right, other question. One other quick question, and we'll do a history lesson. All right. I don't want to take for granted that you know this, but I also don't want to spend too much time on the history to get apart from the law. So here's Halabja. March of 1988. Important because, as I said, we're approaching the anniversary of these events, March 16th to the 19th of 1988. There are, in fact, this is during the Iran-Iraq War, there are, in fact, Iranian military units in the area, in the vicinity of Halabja. So one of the issues at trial is what in the jurisprudence we call the mixed motive. The defense says, this was not genocide, we're simply attacking military units. And in this case, even if we concede that we used unlawful weapons, in this case a mix, a very sophisticated mix of chemical weapons. It's not just one chemical weapon, one attack. It's a cocktail. So there's nerve agent, there's mustard gas, there's a whole cocktail over 3 days. The issue for the bench is, though, what's premeditation, right? Because you don't, in military practice, when you're conducting an armed conflict, have a duty to warn your adversary. Right? You do, however, have a duty to warn civilians. And in the law of war it says where possible, where feasible, where circumstances permit. So that's a critical issue at trial. The Iraqis wrestled with that and said, we find premeditation here for two reasons. One, because when you attacked Halabja with chemical weapons, you took the time, a priori, to pull back your own military units. See? A clear indicia of the fact that you're not conducting a military conflict, you're not using a set of weapons technology in order to gain a military advantage, and your military forces are positioned close to the fight, so that you can capitalize on that temporal military advantage. So the fact that you took the time to withdraw shows premeditation. You see that? And then the second thing is the very fact that if, in fact, you had been conducting a legitimate armed conflict in legitimate ways, the law of war clearly says you've got the duty to warn civilian populations. You didn't warn. What is that? That's premeditation. That shows you really did want to capture the most citizens of this place, and you wanted to capture them by surprise, and you wanted to isolate them, and in fact you wanted to murder them. Hence, the legal predicate for finding premeditated murder, the crime against humanity of murder. Or in the language of the Rome Statute, the crime against humanity of murder that's intentionally carried out. That's the factual basis upon which they conclude that. Now, Halabja is one of the most famous examples of chemical weapons attacks because it got a lot of world publicity. If you Google this, you'll find lots of things on the internet. People incorrectly assume that that was the most stellar, the most shining, the most well-recognized example of Saddam's use of chemical weapons. In fact, it was far from. There are more than 60 documented uses of chemical weapons against Kurdish civilians by the Ba'athist regime. This is only one, okay? And in many ways, not the most severe. And if you want to do a qualitative comparison, it is the most famous because people died in their basements. They died. Unarmed civilians now, men, women, and children, equally alike for an extended period of 3 days, also showing premeditation and planning. Okay? But remember, as I said, because of the military context, at the trial level for this attack, the court the majority anyway, specifically rejected a genocide conviction in favor of a crimes against humanity conviction. okay? Because, and I think if you read, you have to read between the lines a little bit, that the evidence of dolo specialis is mixed enough that they went on the safe side and said crimes against humanity. The crime against humanity of premeditated intentional murder. Does that make sense? Now, this is set in the backdrop, not just, and it really doesn't fit. The Iraqis got a lot of criticism for separating the events in Halabja as a totally separate standalone trial from the larger Anfal case. A lot of people said, well, of course, they're all Kurdish victims, they're all Kurdish civilian victims. Intellectually, it makes total sense. And I'll tell you, I think, why they did separate it. Number one, it's a temporally distinct attack. The larger Anfal campaign takes place in the fall of that year. Okay? The bulk of the Anfal crimes takes place after the Halabja attack. So that's one issue. But the second issue is that the Anfal campaigns themselves, the 8 different distinct phases of Anfal, typically were directed against the countryside. They were typically directed against rural areas and rural villages, and I'll show you some stuff here in a minute that sort of brings this home. Halabja is one of those attacks on a major city, on a major urban area, as a standalone attack. And so the Iraqis said, compounded of course by the fact that you had Iranian forces in the area, and you did have some standing Peshmerga, some Kurdish militia forces in the area. So that made enough sense intellectually that the Iraqis said, let's do these as separate cases because they raise separate issues. I will tell you though, as is common in these areas, many of the common defendants. So the defendants, and this is a reflection of a very different way. In that system and in many other systems around the world, they prosecute events. And they say, what are the crimes and what are the individuals associated with this event? And you can see very different from the way we would do it in the United States. We would say, let us prosecute Professor Scharf. exactly the width of an Iraqi military bulldozer. Aha! So then we link that up with the orders showing that bulldozers moved, and if you've studied the jurisprudence, this is the exact analog to the Srebrenica case, where we convicted General Kerstich on a very similar set of circumstances. The question is, what's the individual grounds of responsibility, right? Your military forces under your control are being used in this way to perpetrate this genocide. Then the real substantive question is, did you order it? Did you aid and abet it? Or were you complicit in that? Is there joint criminal enterprise in the ICTY? In this case, it's a technical Arabic term, different from joint criminal enterprise, but it's the same basic concept. Okay? The concept is estentage in Iraqi jurisprudence. What we would call, it's more than conspiracy. Normal conspiracy means you have precise agreement about a precise crime and a meeting of the minds of a group of like-minded co-conspirators. It's much more than that, because you can't show a precise line and a precise group of people who agree on each and every crime, in each and every situs, in each and every place of a mass grave. So you have a larger concept that we've applied in the rest of international criminal law. Those are key issues in these cases. All right. Here's how you prove genocide. This is actual evidence from the Anfal case. Okay? So here's the documented, this is the way we find this mass grave. Here is the authentication, if you will, right? For those who are taking evidence, right? You've got your best evidence rule. You're going to have to authenticate that piece of evidence somewhere or another. This is how this is done, right? There's computer detailed analysis and experts who testify that yes, what you're now seeing is the authentic representation exactly the way we found it in exactly the same way. And so you document that case. In these cases, this is revolutionary. I don't know of any other case where it's ever been done. It was a short little Guatemalan woman that dreamed this up. She said, when we bring this forensic evidence, it's there, it's real, it's authenticated. She said, but how much more powerful is it if we bring it to life? We're going to put it on mannequins. Precise, because we know exactly how tall these people were. We know exactly the sex, the gender. We know whether they were pregnant or not. We're going to do exact to scale replica mannequins. We're going to bring these people to life. Now remember, of course, you could do this for 200,000 plus victims. Okay? And so, here they are. And these are just a few of them. Again, I don't want to belabor this, but this is trial evidence. Okay? Documenting Kurdish ethnicity straight from the mass graves. And this is what it looks like. Over and over and over again. Now here's the key point, and then I'll conclude. You're matching up the military records of how these campaigns were conducted with eyewitness testimony that says, yes, I was in my village on about this time, about this date, okay, with the mass graves. Now the question is, how do I link these disparate pieces of testimony, these disparate pieces of evidence, to show that this is what's going on? All right, so any of y'all have kids? Anybody moms? Who's a mom here? All right, mom. I'm going to put mom on the spot. Anybody else have kids? If they come to your house early in the morning, and they say, you have a half an hour, and if you're not a mom or dad, you can sort of play along. They come to your house, and they say, you have a half an hour to collect your belongings. You're being evacuated. Now, you have no idea where you're going, how long you're going to be gone, when you're going to come back, if you're ever going to see your home. You just know that the military is coming back to your house in a half an hour. All right, here's the question. The first question, of course, is, Dad, do you stay with your family to try to protect them, or do you hightail out the back door to try to join the resistance and fight these people? That's the first decision. Okay? Many families make different individual personal decisions. But so typically, in the classic Kurdish culture, it's mom who's got this challenge of organizing belongings in a half an hour to go out the door. What do you take with you? Quickly. And then I'll take time for questions. What do you take with you? Critical stuff. And this is important for you CSIers. This is how you prove genocide. These are the nuts and bolts of how you prove. What do you take with you? Quickly. Food. As much food as you can get. Good. Right. What else? Huh?
Huggies.
Oh, good. Good. What do you mean by Huggies? This is important. Now listen to her. This is a wise woman. She says Huggies. What do you mean by that?
Clothing for your children.
As much clothing as you can take, right? So we find these people in mass graves that look like the Michelin people, right? You have a limited amount of space. What do? You wear clothes. You find people with 6 and 8 and 9 layers of clothes, as much as you can wear. Anybody seen the movie, the Christmas Story movie, when the little kid's going to, he can't put his arms down? Well, at least people can put their arms down, but the point is you're wearing multiple clothes. Why? Because it makes them easier to carry. You find that in the mass graves. Good. And that corroborates the eyewitness testimony that says they were moving us and we had to do what we could do. What else do you take? Quickly. You got food, you got clothes. Yeah.
Survival gear,
You know, you're not, what do you mean by survival gear? What does that mean?
like lighter, knife,
Okay, well, stuff, so maybe some cooking stuff, you know, some stuff to make it in some place. Okay, what else? Yeah.
Family memorabilia.
Ah, good, important. You might take your wedding album if you could carry it, if it was big, and if you actually like the pictures. You might very well take out but in this culture, that means you take particular valuables that remind you of who you are and where you come. So you find these valuables on these people in the mass grave. Again, you're corroborating the accounts, the eyewitness accounts. A couple more things. What else do you take? Two more important things that help you pinpoint, and importantly for a genocide case, corroborate the eyewitness testimony. Two more things. Yes, ma'am. Good. Your identification. Well, three more things. That's on my list. Identification documents, right? You don't know where you're going, so you take your identification documents, maybe a passport, maybe it's your family Bible that lineates your lineage. But it's the identification. It's the who I am, right? My identity paperwork, who I am, your driver's license in our culture, etc. Good. Two more things. Two more important things. Yeah.
If you had anything of value,
Good.
jewelry
Good.
or money or something like that.
Good. So in this culture, that means jewelry. You find women wearing all their jewelry. All of their rings, all of their necklaces, all of their gold. It's portable. I take it with me as much as I can. Good. Two more things.
Are there religious things? You said Bible.
Yeah, I think
equivalent of cross or-
that's important. Yeah, but that's, to me, that's this identity, this who I am. So we've already talked about that. Two more important things, and then I'll take questions. Yeah.
pets.
Huh? No, no pets. No pets. Bye, Fido. Now, let me give this to you, because this is really important in the context, and then I'll take questions. One, your prescriptions. You take your medicine, your prescriptions. And what does that do? It says, when you find this mass grave some 15 years later, it says, here's a prescription from this village, expires on this date, filled this date, and that's how you corroborate eyewitness testimony. Very powerful. And it's objective, and it pinpoints that time, that place, and you use that to buttress your eyewitness testimony. I'm sorry, I kind of got... here are mass graves, obviously, of survivors with ligatures still over the eyes. You find people with their hands tied behind their back. Now, the most important thing, moms, I'm surprised no mom said this. How many folks ever went on an extended car trip with your parents? Come on, be honest. And your parents always said what? Take something to do. You're going to drive me crazy. Inside of 15 minutes, if you don't have a Game Boy or a TV or a video or a book or a something, you're going to drive me crazy. And the moms all said exactly the same thing. Take something to do, children. But importantly, something that reminds you of who you are. Something that reminds you of where you come from. Right? So you find, particularly children, and in one particular story from one particular mass grave, you find children who died with their mothers wrapped around them. They tried to protect them, so they're wrapped around them, sometimes holding them. Sometimes you find children's hands, the bones are separated because they're inside the garments of the mother, right, clinging to them as they're killed. They die with their toys in their hands. Maybe it's a doll. Maybe it's a ball. Maybe it's a particular set of gaming devices. But they die with something to do in their hands because you don't know when you're going to go back and you want to remember who I am, where I come from. That, folks, is how you prove genocide. When you can have an entire mass grave filled with ethnically identical and corroborated eyewitness testimony from various parts that shows widespread and systematic planning, that shows orchestrated. You know, these mass graves don't just dig themselves out in a particular location. There's military orders that back all up. That's how you prove genocide. And the very simple, the last thing I'll say, and then we'll take questions, is in the Anfal case, you had abundant evidence of that, hence genocide convictions. In the Halabja case, you didn't. You had lots of evidence about what happened and how it happened, the chemical weapons attack. What you didn't have was nearly as much corroboration of the circumstances and the processes, hence the judges in that particular case took, I think, the prudent, maybe the safe way out and said crimes against humanity. Except for the dissenters who took maybe the larger position and said, you can't disaggregate this one event in this one town from the larger campaign. These, after all, were Kurdish people. This, after all, are Kurdish civilians in a Kurdish village, Kurdish town. And therefore, there's clear, larger circumstantial evidence that's relevant to genocide findings in this case. That's what the dissenters say. Okay? They just get outvoted by the pragmatists. Does that make sense? All right, questions? And I'll show you some more mass grave stuff. Questions? I showed this slide in Uganda. I was doing a slide in Uganda, and one of the Ugandan women was horrified. She said, how can you show that baby with electrodes on his head? I'm sorry. No. It's just to illustrate confusion and mental complication. The one thing I'll tell you as practitioners is that these issues are complex. Don't shy away from, as lawyers and as law students, the detailed analysis of the law. These complicated trials are not susceptible to simple overstatement, to overgeneralization, to sweeping, broad. No. You have to approach these things and take some pride in this, folks, as legal craftsmen and craftswomen, craftspeople, technicians, to take the law and use it in a very skilled, very precise way against a particular set of facts. And when you do that in these cases, you result in genocide findings. But resulting in a genocide finding is not what's most important. What's most important, do you think? As the lawyers and as the craftsmen and as the judges, what's most important? In my mind, that you can reduce that to writing, that you can explain it for all the world to see, for all of history to see, in a way that's powerful and persuasive. Because, ladies and gents, that's what lives on long after you and I are gone, is the technical craftsmanship. Okay, first question.
All right, so Mike, have any courts anywhere in the world started to cite the precedent of the Iraqi High Tribunal yet?
Yes, they have. There's some footnotes in some of the ICC jurisprudence, actually. In the Lubanga case, there's some footnotes. They haven't cited them for the technicalities. They've cited them particularly on the command responsibility grounds. But yeah, it's emergent because the jurisprudence is not widely available and it's not widely understood. These cases are not cited yet in the genocide jurisprudence. Again, they're just not available. So we're hoping to change that. We're going to fix this problem. Yeah, that's true. I forgot about Cambodia. That's right. Yeah, quick question. Okay, not a quick question. You raised your hand. Yes, sir.
Is there a genesis to reparations for the Kurdish people from these criminal trials?
Long, complicated question, but the question is about reparations. This is a civil law system, and so in the Halabja case and in the Anfal case, there's a whole class of victims advocates that are doing that. That's all they're doing. It's representing the interests of the victims, and then, in fact, in the Anfal case, one of the most powerful, visceral moments of trial is when the judge looks down at Ali Hassan Al-Majid and says, oh, by the way, the lands, the property, the cars, all that's going to be forfeited to the court to help pay compensation to these victims. He went nuts. Call me a genocidaire, I can take that. Take my stuff, that bothered him. Okay, and it bothered Ali Hassan. But yeah, there's a whole dimension of this, which is drawn from their, as I said, the backdrop of their criminal procedure practice. That's the norm for them. But you can, there's a lot of issues to be drawn here, how imperfect the solution that is. Because it's only that class of victims that are lucky enough to be pled in pleadings that derive from that. It leaves a whole other broad swath of victims, and this concept of what we would think of as a class action, not in their law. So this is a residual problem. How do we properly get compensation or some form of remuneration? And even at that, and just on a moral level, what kind of money makes up for this? It's a shallow, pathetic substitute for having your parents alive. So let's be honest about that. And I think, again, that calls me back to the critical importance of this case law. Right? You want to call it genocide? Here's the legal, technical analysis of why it's genocide. No question. For all the world to see, for all of history to read and recognize. That's important. That's really important. Okay, a couple more questions, quickly. Yes, sir.
Have there been any lower level soldiers or colonels that carried out the acts of genocide? Have there been any prosecutions for those individuals?
Yeah, remember I said there's a class of victims. So in the Anfal case, you get all the way down to a very mid-level, I would say a low to mid-level command authority level, very low. So it's not just Ali Hassan Al-Majid, it's not just the big fish, it's all the way down to the intelligence station chief. You know, it's a very, very horizontal swath of defendants, which arguably is a better way to think about these things, right? So Srebrenica, wouldn't it have been better to have one big consolidated Srebrenica trial and have everybody that we can prove was affiliated with that trial, no matter what their involvement, from top to bottom on a vertical basis? And the Iraqis did as much of that as they could prove, including some very, very low-level people. In the jail trial, of course, full acquittals. Because the judges said, yeah, they might have been involved, but not in the same way, not sufficient based on the evidence to sustain criminal convictions. So typically you've seen that pattern of lower-ranking people either A, being acquitted, or B, getting much more lenient sentences. That's been the pattern. Okay, last question. I thought I saw a hand over here. No, you already had your quota. I thought I saw another hand. All right, ma'am.
Okay, my question is just in terms of the domestic system in the aftermath of these trials, is there a way that the legacy of the court is kind of being folded into the criminal practice, the lessons that they've been learned from the trials, whether it's fair trial practices or any of those kind of standards being folded into?
That's a really nice, elegant question, and I think elegant in a way that it leaves me on the note that I want to leave you on, which is pointing to the future. These things are not just circumstances where you say, yeah, we did all this and it's now put in a box and it's lost forever. 2 or 3 very important things you leave. And of course, the obvious, you leave these historical records, you leave these cases. That's important. But your question goes to the systematic benefits. You leave an entire trained cadre of judges and prosecutors and, dare I say, defense counsel that now understand this body of law. You leave that in place so that they're very literate in this and they like to talk about it and they've learned this body of law. I think that's important on a systematic level. And the other thing that you leave is a little more subtle, but the expertise and the insights from the West brings a whole array, which Libya, Tunisia, Egypt, and I could go on, now needs, maybe one day Syria needs, this other range of expertise. How do you secure evidence? How do you do chains of custody? How do you do this kind of forensic evidence in court? How do I do an opening statement? Very different. I mean, I wrote an opening statement for one of these cases and I handed it to the Iraqi and I said, if you're Mike Newton and if you're in The Hague, this is quite a good opening statement in my personal opinion. But you're not Mike Newton, you're not in The Hague. And what he did was he took it and individualized it and made it brilliant in his own way, in his own system. That's a pretty important legacy. Because you leave those trained people, the registry people, the victim witness people, the evidence custodians, you leave all of that in place, which taps into the larger philosophical debate of whether we want to centralize all these things in The Hague and have world-class expertise, but it's all centralized, or whether we prefer the ink and water model, where we take these principles and we diffuse them across societies and across cultures and across legal rules of evidence, bearing in mind that they're always going to be slightly different in these particular contexts. And that's pretty important. But yeah, you definitely leave a long-term legacy. The larger question is, how does that society, how does that legal culture adopt to that? North Korea is another example, or we could go on. Okay? And I think that's important. Thank y'all for your Friday. Enjoy this
We get evicted at 1 o'clock. Michael, I want to thank you on behalf of the law school and our students who were here today and our visitors. That was a wonderful presentation. Thank you again.